Greetings, everyone. This is Dr. Weaver. I wanted to go ahead and create another voiceover. This time, well, I guess like last time, I'm going to start on slide 18. And this particular topic discusses legal issues in nursing and healthcare. A very important topic. Um, and as you all know, um, the concept of law, professional accountability, legal liability, negligence, malpractice, and criminal offenses are the types of issues that we as clinicians will have to, or can face, I should say, can face. And so having a knowledge of the legal aspects of nursing practice will certainly, hopefully, keep everyone out of trouble. But of course, it can be quite easy to be named in a lawsuit. I mean, as we all know, there's so many errors that goes on in healthcare, and all it takes is for you to be a part of a patient group that has suffered some kind of an injury due to medical errors, and then you can be named in a lawsuit. So. Um, Pretty easy to be involved in these situations. And so hopefully this discussion will help you guys to understand what you can be faced with, and you can take steps to avoid these types of issues, thereby not only, well, first and foremost, keeping the patient safe, but also keeping your license safe. All right. So anyway, let me go ahead and share my desktop. See, I think that is it there. All right. So again, we're going to start with slide 18, and this deals with, again, civil law. As you all know, we'll discuss some of this information in class. But here we are starting with um, what is referred to as gross negligence. Now, in some cases, the neglect act of the nurse is so reckless and reflects such a conscious disregard for the patient's welfare that it represents what is referred to as gross negligence. All right. When the nurse acts with a complete indifference to the consequences of his or her actions to the patient, the court may award special damages meant to punish the nurse for this outrageous conduct. Now, these damages are referred to as punitive damages. I'm sure you guys have heard of that term before. All right. Now, each state has established standards to determine when punitive damages may be awarded. There was a case in Mobile, I believe it was Mobile, Alabama. It happened in the infirmary. I guess it was called Mobile Infirmary Medical Center versus Hodgkin. The jury actually awarded someone $2.5 million in punitive damages. It was later reduced when a new graduate who was not yet licensed administered 5 times the ordered dose of digoxin, 5 times. Digoxin, if you all don't know, is a very potent medication, cardiac medication. It's actually a cardiac glycoside, and they give it to strengthen the heart muscle, thereby improving the patient's cardiac output. And with this drug, I mean, it has to be within, or the amount of the therapeutic amount of the drug has to be within a certain range. And I can only imagine, given 5 times that dose, it can be pretty significant as far as causing a lot of harm to this patient. All right. Now, again, now remember what I said, new graduate, right? And didn't have a license yet, but still pulled into this lawsuit. Now, the jury found that the new graduate had been improperly supervised by the novice nurse assigned as a preceptor by the shift charge nurse. So even in this case, the charge nurse can even be pulled into this. The novice nurse, meaning a new nurse, was tasked with precepting this new graduate, again, who did not have a license. And so, not a very good place to be, for lack of a better way of articulating that. When your job, your license is on the line. I'm not even sure this person would have been able to get her license or his license. I'm not sure. I don't think they would be able to. That's probably an automatic. Um, well, I mean, if she or he never took the test, then wouldn't be a revocation of their license, but probably won't allow them to become licensed. And I guess that would also depend on the laws of that state. But anyway, so claims of negligence may arise. This is something to really listen to. Again, claims of negligence may arise when student nurses provide care. That's right, you heard me. Student nurses. So even you guys, being just students, can be brought into a lawsuit. And so, typically, when I take when I take students to the hospital, sometimes I don't have a lot of time for my pre-conference because, by the time we get there, it's about 6:30, right? And I have like probably within 15 minutes, I like to have my students out on the floor so that they can take part in the report or the handoff reports. And so it doesn't give me a whole lot of time to go over different things. But one of the things that I do tell students is do not perform any nursing task or any task if you don't know what you're doing. All right, if you're uncomfortable with it, explain that to the nurse, or come get me, of course. But do not do anything that will bring harm to that patient. If you don't know, say so. All right, so that's one of the pieces of advice, if you will, or instructions that I give students with the small amount of time that I have. All right. Now, the emphasis on patient safety and reporting preventable adverse outcomes has brought an increasing number of student errors to light. So there have been quite a few errors that students have been making, and so and this has become even the more known. Now, because the student is not yet a licensed professional, the faculty member, right? Faculty, me, or a licensed nurse who is supervising the student is often named in the lawsuit. And I don't want to be named in a lawsuit. So again, I will say, just make sure you guys don't just don't perform any task and you don't know what you're doing. All right. Now, the higher court affirmed that a patient may assume that the care that he or she receives in a hospital is provided by that institution or that hospital. The patient can assume that the student and instructor are agents of the hospital, unless the patient has been specifically informed and has agreed to receive care from the student. But if it was not explained to that patient that I'm the instructor and this is my student, will you allow the student to provide care for you? If that is not done, then the patient can automatically assume that you work for the hospital, that you're part of the staff, and so, because a student nurse is not yet a licensed professional, if a lawsuit is filed, the alleged claim is usually referred to as ordinary negligence rather than professional malpractice. So it'll fall under the category of ordinary negligence because of the fact that the student is not yet, excuse me, is not yet licensed. All right, so they will refer to it as ordinary negligence. Now, of course, when someone is licensed, then it would be referred to as professional malpractice. Actually, I forgot to increase the size of this. Right, criminal law, criminal negligence. I have so much stuff on my desk. I get so much mail. All right. So criminal negligence applies when the negligent acts of the nurse, normally referred to as unintentional civil wrong, also constitute a crime. All right. Now, in most states, a nurse can be prosecuted when the conduct is deemed so reckless that the action results in serious harm or death of the patient. Now, nurses with criminal convictions accounted for approximately 10% of the disciplinary actions taken by the State Board of Nursing between 2003 and 2013. And that's a pretty good number. And we're talking about, again, nurses who were criminally convicted. All right. You guys remember the nurse who I believe, gave the patient a paralytic agent and thought it was something else. I can't remember the story specifically, but she was brought up on criminal charges. I don't think they ultimately were able to convict this nurse, but more than likely she'll never be able to practice nursing again. And it was probably, from what I understand, a systems issue. It was not necessarily an individual, reason for, um, this medication error occurring. So now other negative consequences that a nurse faces when criminal charges are filed include the loss of his or her job and disciplinary action by the state licensing board. Right. Now, even when the criminal charges are not supported, the nurse's license can be suspended or revoked. And of course, out-of-pocket fines may be levied by the board if there's evidence of violation of the Nurse Practice Act. Now, an attorney may have to be retained to represent the nurse when criminal charges are filed, and the nurse's malpractice insurance generally does not cover the attorney's fees in this case. And so basically, this will all fall on the nurse. Now, neither is the nurse's employer. They're not even obligated to pay the legal fees of a nurse who is charged with a felony. Again, it would be totally on the nurse who may have broken the law. Now, nursing care that is that is deemed deplorable by the courts may result in disqualification of the nurse's employer from participation in the federal government Medicare and Medicaid programs. So, you have these these hospitals, right? They receive federal dollars in the way of Medicare and Medicaid. And so, if a court has deemed the act, the nursing care as deplorable, then they stop receiving funding. And of course, when you stop receiving funding, that means you go out of business, basically. All right, because you can't. I don't know what the percentage is per se, but it has to be fairly a significant percentage of hospitals receive their monies from in the way of Medicare or Medicaid, because most people in a hospital are over the age of 65, and so about that age you typically are on Medicare. I mean, they have other payers like private payers and so forth, and but Medicare, Medicaid, especially Medicare, would represent quite a bit of their income. All right. Now take a look at the last bullet point here, where it talks about um, conservative estimates suggest that as many as 98,000 patients die each year as a result of negligence and malpractice of healthcare providers. Now, this particular statistics stat was actually cited in the Institute of Medicine, where they were called Institute of Medicine a while back, and there's another name they go by now. But anyway, they actually cited this. But it was often suggested that the number is actually much higher than 98,000. And so just imagine with the number of nurses who are practicing, um, you know, the odds may certainly be against you as far as um, possibly ever having to appear before the Board of Nursing. I've never had to appear before them, but I tell you one thing, there has been some instances where something could have gone awry, and I could have been obviously named in a lawsuit. And I'm saying that in terms of sometimes the situation that you're in, where maybe you have too many patients and not enough staff, and you're just running, up and down the hallway, in and out of rooms, trying to keep these patients safe, and you're only one person, and it's just really hard to. I mean, I didn't kill anybody, but they're just situations that you might be placed in that are deemed, rather dangerous. That can, result in you having to appear before these folks. So not a pretty sight, for sure. All right, but critical. All right. So in no case may a nurse provide a defense of only following the provider's orders against allegations of negligence. The the Nurse Practice Act, licensing board rules and regulations, and nursing case law have listed the nurse's independent duty to evaluate all provider orders before implementing them. In doing so, the nurse must consider 2 points. Is the order lawful, and is the order in this particular patient's best interest? So what does this say? So your physicians, they write orders, right? And something goes awry. And of course, there's a lawsuit that is filed, and nurses have actually tried to say or use the defense of, well, the doctor wrote the order, right? And so what you have to think about is you also are getting all this education. Don't ever follow anyone blindly. Um, in terms of, um, well, can't say that, but when whenever you are looking at orders in the hospital that has to be implemented, you want to make sure you know everything there is to know about your patient, and is this order going to be safe for this patient? Because if that patient, if that order is not safe for that particular patient, then it is going to be expected that you will not carry out that order. For example, um, I believe the drug is called Coreg in regards to, that's not the example I wanted to give, but I'll probably give the other example too. But in heart failure patients, you have to be very careful about giving the drug Coreg, Coreg, because it can cause them to go into even more severe heart failure. Now, the other example I was thinking about before I gave that example is that, say if you got a patient with heart failure, right? And let's say maybe severe heart failure. And the patient's urine output is dropping, um, um, and the patient is not producing any urine and whatnot, likely because the kidneys are not being perfused. Then you can, and let's say the physician says, well, go ahead and give 1 liter of fluid over 30 minutes. That's a lot of fluid to give a patient with heart failure, because at the heart, which handles volume, you know, cannot handle that amount of volume in such a short period of time. But if you go ahead and you administer the IV fluids, and the patient goes into what we call pulmonary edema, which is a medical emergency, and dies as a result, or suffers some irreparable harm, then you can get in trouble, because you know about that patient's history. You know that patient has a cardiac history, in particular heart failure, maybe hypertension, coronary artery disease, and you still gave that the IV fluids. In these cases, you want to tell the physician, hey, this is what the case is about this patient. Maybe the doctor is in a deep sleep and don't know what they're saying. Who knows what the situation can be? It can be a number of things, but you want to more or less question that order tactfully, right? And if the physician continues to insist, of course, that's when I would get my charge nurse or the nursing supervisor. I wouldn't just go ahead and give it. All right, so I want you guys to keep that in mind. Keep the patient safe, keep you safe. All right. Now, each nurse has an absolute duty to take some positive action to prevent harm when orders are inappropriate or incomplete, or when the actions of another health care provider endanger the patient's well-being. Now, this principle, this is what we call affirmative duty, is well recognized in law and also in ethics, like do no harm. Now, the ANA Code of Ethics for nurses and the American Medical Association Code of Medical Ethics recognize the central role of nurses in preventing patient harm. A second principle underlying the nurse's legal and professional obligation to address questionable physician's orders or plan of care is patient advocacy. You are advocating for your patient, and that's why you have to question orders that are incomplete, orders that are not appropriate for that patient. All right, please don't ever hesitate to advocate for your patient. I know sometimes you may feel like, yeah, but I don't, if I don't carry out what the doctor told me to, then I may lose my job. Well, you know what? Even if the doctor was right, but with your limited knowledge, if you felt that it was unsafe, just immediately get your charge nurse, get someone who's much more well experienced. One thing about it, never hesitate to ask questions. All right. Don't if when I don't know something, and I've been a nurse for many years, I will go to someone, especially who has worked on that particular unit, who knows the unit, their procedures and policies, and the population and what have you. I would be quick to ask them, hey, this or that, whatever that is. before I just proceed with doing something that may cause irreparable harm to that patient. So you guys need to think the same way, right? Now, the nurse's duty to speak out in order to support and protect patients has been reaffirmed by the Joint Commission in its Speak Up initiative. So the Joint Commission has a an initiative referred to as Speak Up, and that's what you have to do. Now, nursing care rendered in a life-threatening emergency may breach the standard of care required under ordinary circumstances. Now, what this basically means is, we have this standard of practice, that is noted in the Nurse Practice Act. And ordinarily, you follow that standard of care. However, in an emergency situation, say if there's a mass casualty or something or another, and you have to provide a certain care that may cause injury to the patient. But if you hadn't performed that particular task, maybe the patient would have lost life, perhaps limb, or what have you. And so, in this particular case, because it is a life-threatening emergency, it can be breached. In other words, no one would expect for you to follow the usual standard of care in these circumstances. I may have to remove a patient from a burning vehicle quickly before I can actually stabilize the patient's cervical spine, and which may, of course, cause the patient to die or become permanently paralyzed. And so the usual standard of care is to stabilize the spine and, move them in a safe manner, in a certain manner. But in the case if the vehicle's getting ready to blow up, well, guess what? I got to move this patient like right now. But some people, they have been sued when they saved the life of someone, but the patient ended up with, some type of injury that probably wouldn't have happened had the standard of care been followed. But in some cases, you just can't. Now, for nurses working in federal or state healthcare facilities, a defense of governmental immunity may be used, because you can't really sue the government, right? Well, you can try, but like in all likelihood, you won't be successful. All right. So when a nurse works in these for these particular entities, they can typically use the defense of governmental immunity. So it's hard to sue them or these individuals, because they're under the auspices of the state federal. Now, laws have been enacted that shield individual healthcare workers employed in federal and in some state facilities from personal responsibility for damages awarded in malpractice cases. Nurses employed by the Department of Veterans Affairs, or the VA, the U.S. Public Health Service, also the National Aeronautics and Space Administration, and also the Defense Department, Department of Defense, are shielded from civil suits when into performance of professional duties. And so again, they have that kind of immunity. Now, state immunity statutes, of course, they vary. You may not be protected, under the state. In some instances, individual states have not waived their sovereign immunity from lawsuits. So in these cases, the state is not substituted for the individual healthcare provider in malpractice cases. And so essentially you're on your own. So nurses and physicians are liable for their negligent acts in these in these particular states, and are personally responsible for damages awarded. All right. Now, it may be imperative in this circumstance for the healthcare professional to have individual malpractice insurance. One of the malpractice insurance, and I'm not sure if students can get this, but it's called it's NSO. Let me see, NSO. Let's see, nursing. Yes, it's called nursing service. I think it's called Nursing Service Organization. Yeah, Nurses Service Organization. And it's basically malpractice insurance. But I'm not sure if students can have this. It actually can cost as low as $119 a year. I believe several years ago when I had it, it was like $100,000. And I'll be honest with you, if um, I was still working in a hospital, I would certainly do it. Let me see if there's something for students. Well, I don't want to take up too much time. Let's see. I don't want to take up too much time. Maybe this is something we can discuss in class, but I believe there is some type of insurance you can get as a student, and again, it may be worthwhile. Um, yeah, maybe certainly worthwhile. All right. Now, also, as far as the Good Samaritan laws, Good Samaritan laws may limit a nurse's liability um, or shield the nurse from a malpractice claim if the nurse renders assistance in an emergency situation that occurs outside the employment setting. You're driving down the street, somebody is involved in an automobile accident, and you render aid. So the Good Samaritan law would shield you from that. That's something I think most of you would know about anyway, because I think they even talk about this when you're getting your driver's license, right? Now, although in most states the nurse owes no legal duty to an accident victim, in other words, you don't have to stop, once the nurse makes a decision to stop and render aid, which is an ethical decision, a nurse-patient relationship is now established. Right. So you can have the decision or make a decision to keep it moving or to stay and render aid. And so now, when the nurse renders care at the scene of the accident, he or she is required to render the standard of care. At this point, the standard of care that any reasonable and prudent nurse would render in a similar situation. Right. Um, Now, to prevail in a malpractice suit under the Good Samaritan laws, the injured plaintiff or person injured must prove that the nurse intentionally caused the injury or was grossly negligent. And that may be a bit hard to prove. Um, Now, each nurse should be familiar with his or her state specific Good Samaritan statute, so you can, determine ahead of time. Hey, if something happens, do I keep going or do I stay? I know a young lady. She's a nurse. Um, she actually stops at just about everything, so she's brave. Um, I don't know if I would. We live in such a litigious society, and I know that may surprise some of you that I say I don't know if I would, but I really don't. Um, Again, people are ready to sue, even if you save their lives, and so that's something to really think about, right? Right. So statute of limitations in malpractice cases. Now, each state has established a time limit in which a person can initiate a lawsuit. Excuse me. Now, although many states have established a time limit of 2 or 3 years from the date of the patient's injury or death in which a plaintiff must sue, statutes of limitation vary widely from state to state. And so you have to look at each state's statute or laws regarding the statute of limitations. In some jurisdictions, a termination of treatment rule exists. All right. And this is predicated on the assumption that some injuries result from a series of treatments over time. Right. So in other words, say if you're receiving a medication, you're going to receive the medication over a year, right? Um, say January 2023, you start receiving this treatment. And so you throughout the whole year, let's say up until about November, the treatment stops, right? So whether it's 2 or 3 years, let's say if it's 3 years, from the date of termination of that treatment, you got 3 years. Not when it was started, but the time that it was terminated. All right, so you got 3 years in the future, if you will, from November. So what is that, 26, 2026, 23, 24, 25, 26, yeah. So 2026, November, not January when it started. All right. So again, so in this case, the statute of limitations does not begin to run until the treatment has ended, because that's when they may have possibly, or the effects of the treatment may be more clearly seen. Now, other rules and regulations govern the tolling, what we call tolling, or running of the statutes of limitations. So, so the court recognizes that an injured party cannot initiate a malpractice case until he or she discovers that some harm was done, which is called the discovery rule. Now, this can occur when healthcare providers actually hide, right, the facts in the case of an injury through fraud, deceit, concealment, such as through fraudulent or misleading entries in the medical record, documenting something that is not true, destruction of evidence, and also destruction of the medical record. And so this can also result in, in other words, like the statute of limitations, more or less once this is discovered, even if it's beyond the 2 or 3 years, whatever the state, statute is regarding statute of limitations, then the patient will have more time because something fraudulent, so to speak, has occurred. Now, the statute of limitations also is altered when a foreign object is left in the patient's body. So until the foreign object is discovered, right, the statute of limitations does not begin to run. So you had some abdominal surgery, a piece of 4x4 was left in the stomach. And then 10 years later, when you develop maybe some complication from it, well, that's kind of long, but say 5 years later, you develop some kind of complication, then the statute of limitations is not going to, it will not, there will be no statute of limitations that would preclude that patient from getting some kind of monetary damages and what have you, award, if you will. I'm sorry. Now, states have rules that regulate the tolling of the statute of limitations in cases involving mentally incompetent adults and minors. Now, in the case of an adult patient who is so severely injured that there is loss of mental capacity, the statute of limitations may not begin to toll or count until the patient regains mental competence. So again, there would be no statute of limitations that would, prevent the patient from being able to sue in the future, because you can actually, hopefully the patient will get better and then they can commence their lawsuit. Now, the statute of limitation varies in the case of minors, and may expire only when the child reaches the age of majority, and that is 18 or 21 years of age. And so there are different ways of looking at this. It's not black and white or linear. You just have to look at each individual situation. Now, when errors occur in practice, studies repeatedly confirm that telling the patient or the family member about the mistake, which is a kind of a voluntary disclosure, results in far less severe ramifications for the clinicians and the healthcare facility. In other words, when you do something wrong, tell it almost immediately, because when you trying to conceal, delay, or what have you, then the consequences are much more severe. All right. Now, in 2001, the Joint Commission established a new patient safety care standard that required institutions to have a process in place to disclose unanticipated outcomes to the patient. So this accrediting agency has gotten involved in this particular discussion. Now, disclosure of errors and unanticipated adverse outcomes is a key element of the national patient safety movement. All right. Now, when an unanticipated outcome occurs, the provider is generally responsible, not the nurse, for discussing the situation with the patient and or family members. Other agency representatives may be involved in the disclosure process, and that might include an administrator, the risk manager, or an attorney, the hospital's attorney. The nurse should not assume responsibility for disclosure before speaking to the provider and agency leaders. And so with that, I suppose the nurse can, but certainly have to get permission from the leaders in the organization. I wouldn't personally feel comfortable providing that information. To me, that's on the doctor or the administrators or whoever. All right. So reasons for malpractice insurance. Why should you get it? Right. So most states recognize nurse malpractice as a legitimate claim in a civil lawsuit. In other words, more nurses are getting sued or can be sued now, and states are recognizing as such. Functions for RNs and advanced practice nurses are expanding. We're called upon to do even more, and the more you are called upon to do, the more at risk you are of of a problem occurring, if you will. Now, increasing floating and cross-training mandates. In other words, let's say, for example, you typically work on a med surg floor, but the staffing they're so short in staffing, they pull you on, let's say, an oncology floor. And, each population of patients, they require certain treatment regimens and protocols and procedures and all. And so that places us at risk because if we weren't trained to do these things, then it might be, could result rather in a patient's harm to the patient. And so for that reason, getting malpractice insurance would be paramount. Nurses have increasing responsibility for supervising subordinate staff. And so remember the delegation that we have to carry out, where we are delegating to a patient care tech or whoever under our jurisdiction, if you will. And so, they can make mistakes, and of course, it falls on you. It can fall on you, and so again, a good reason to have malpractice insurance. And some employers may fail to initiate an adequate defense for nurses. In other words, they leave you out to hang by yourself. So, maybe prudent for you to go ahead and get that insurance because you're going to be on your own. All right. There is a growing consensus rather appears to recommend that because of the changes in healthcare system, civil law and insurance company policies all nurses should purchase malpractice in assurance. Now, other considerations that the nurse must take into account when considering malpractice insurance include whether he or she is employed by the federal government. So in this case, if the nurse may be shielded from personal liability by federal tort statutes, although some states still uphold the doctrine of sovereign immunity, making it impossible to sue a state-run medical facility for negligence. In these states, it is virtually a virtual necessity for nurses to purchase malpractice insurance because healthcare workers become the only available targets in a malpractice case. And so maybe really prudent for you to obtain, insurance. In fact, I'm, just having this conversation with you guys, so to speak. I'm kind of thinking about getting me some malpractice insurance because you just never know, especially if you go to clinical with students. As far as liability is concerned, personal liability, now within the context of nursing practice, the nurse is always accountable for the outcomes of his or her actions in carrying out nursing duties. Now, the rule of personal liability requires the professional nurse to assume responsibility for patient harm or injury that is a result of his or her negligent acts. Now, the nurse cannot be relieved of personal liability by another professional, such as a provider or nurse manager, who asserts, don't worry about it. I'll take responsibility for the consequences. You're going to be held liable. So don't let a manager or a physician tell you to do something and, they'll cover you. Don't do that because they will get you. All right. Now, in 1989, the American Nurses Association summarized the most frequent allegations of negligence levied or leveled against nurses in malpractice cases. So take a look at box 8.4. These charges have not substantially changed in the ensuing decades. And so these are the types of charges that have been around, in other words, for quite some time. Now, as nurses assume more and more responsibility for monitoring and care of patients with complex health problems, the claim of failure to rescue is made with increasing frequency. And what that basically means is that, for example, you see that a patient is deteriorating and you fail to implement nursing interventions that turns that situation around. Like a patient is going into respiratory distress, but it's happening subtly, and you're not recognizing these signs and symptoms that are occurring, and then the patient several hours later they end up in respiratory or cardiac arrest. All right, so you failed to rescue. All right, this is why they have also rapid response teams. When you recognize something very subtle that is happening with your patient, for example, the respirations are increasing over a period of time, the blood pressure is dropping, or the heart rate is increasing over a certain period of time, or maybe the urine output has decreased significantly. These are some of the issues that you want to get the rapid response team or getting the physician involved quickly. Otherwise, it can be considered failure to rescue, and people are being sued for this because, you guys have to be able to recognize, and hopefully your med-surg course is complex. Whenever you take that, they teach you how to recognize when a patient is deteriorating. Now, nurses may be educated to implement effective risk control strategies that reduce these claims. And in this case, again, when I was teaching complex, I was teaching students how to recognize those issues that present themselves that would call for the rapid response team. All right. And so if you can anticipate that these issues may occur, then you can get out in front of it. That's one of the reasons why they actually created the rapid response team, is because what they discovered, as far as the research is concerned, was that before that patient went into full cardiac or respiratory arrest, several hours before that, they were showing some pretty early signs and symptoms that was not caught by the nurse. And so had the nurse intervened much sooner, then you could have averted such issues as that, and even avert a transfer to an intensive care unit, right? Now, we'll also talk about personal and system-wide strategies in the next sections as well, right? Now, many nurses practice under the misconception that they are protected from personal liability when employed by a healthcare institution, such as a hospital, right? So, for example, someone might say, why would a patient sue me personally? I don't have the financial resources of this, right? Of like a hospital or nursing home or what have you. I don't have the deep pockets for it, so why would they sue me? They will sue you. All right, you got something to take. Nurses can and have been individually named in lawsuits and found negligent. Damages can be levied against the nurse's current assets, and future earnings for negligent acts. So they can come after your money, right? Furthermore, as Snyder reported, hospitals now. Say the nurse gets sued by the patient, right? But hospitals have also come after nurses or sued nurses in order to recoup financial losses suffered when they were required to pay damages for the alleged negligence of the nurses named in a malpractice lawsuit. So if that nurse was named in a malpractice lawsuit along with the hospital, and the nurse was found negligent, the hospital would come after you to get some of their monies if they had to pay a certain amount in damages. They come after you. Not very pretty, is it? Not very pretty. Now, new models of patient care often mandate floating, cross training of patient care staff to enhance efficiency and reduce staffing cost. In other words, we're floating quite a bit more now, and we're being cross trained because then, you don't have to hire as many people in these instances. And whenever you have a need, then hey, here's a nurse over here who can who can rather float to this particular department and provide safe and effective care for this patient population. Now, these models of care have increased the personal liability of nurses. Sometimes they might send you somewhere where you have no idea how to manage those types of patients. Remember in during COVID, there are so many patients on ventilators. I mean, you had doctors who, for example, I think one of the things I heard was that a physician was a plastic surgeon and was in the ICU managing ventilators. So, you never know, right? You may have to float from the medical surgical unit to an ICU to provide care for that patient because there were so many of these patients. Now, professional nurses must be cognizant of state statutes and case law when asked to perform services outside of their usual area of practice. And this is why knowledge is power. This is why you have to educate yourselves on these state laws so that when you anticipate, see that you're getting ready to be placed in a situation, an untoward situation, then you can speak up, of course, with knowledge. Now, in no case is a nurse permitted to perform tasks or render services for which he or she lacks the requisite knowledge and skill to do something, to do so competently. So if they haven't really trained you properly, you don't have to accept that assignment or perform that task. And of course, you want to speak up and say so. Now, the concept of personal liability extends to nurses who function as team leaders, supervisors, and also upper level managers. Team leaders, charge nurses, and managers are held to the standard of care of the reasonably prudent nurse employed in that role. So they'll be judged, if you will, similar to someone who typically performs those tasks. These leaders, if you will, they will be judged the same. Claims of negligence leveled against charge nurses generally surround functioning as a first responder in emergencies, triage of patients and allocation of staff and equipment, and also delegation of patient care task. Right. Claims of negligence have been leveled against these nurses for these things. Now, nurse managers and administrators at the upper end of the management ladder also may be held liable for inadequate training, training staff, failure to periodically reevaluate staff competencies, which is why in that role, you must know what your people are able to do, what your staff are able to do, but they can be held liable if they do not do these things, reevaluating the staff to see if they are competent to provide care. And also failure to discipline or terminate unsafe workers. Maybe they're your buddy, and I like this person, and so I'm going to keep them around and whatnot. And so you can be held liable for that. Now, team leaders and charge nurses who are responsible for delegation and supervision of team members must be absolutely clear about the legality of patient care assignments. They must determine whether it is reasonable and prudent to delegate a particular task on the basis of their knowledge of the worker, the patient status, and the current conditions in the work setting. And so when delegating to your subordinates, in other words, you need to know if they have the requisite skills and knowledge to carry out those tasks safely and effectively. Otherwise, you can be held liable. Now, although a nurse is never relieved of personal liability, the doctrine of vicarious or substituted liability permits a person to also sue the employer for negligent conduct of nurses within the scope of their employment. So this, in other words, allows the patient to go after the hospital, not just the nurse, but go after the hospital because the hospital hired this person and they didn't ensure that the person was, or this nurse was adequately trained and competent. Now, vicarious liability is based on the legal principle of respondent superior. This is a Latin term that means let the master answer for the actions of subordinate or servants. In other words, the master being the hospital itself, being a much larger entity. Now, because the employer has some control over the worker, the courts have affirmed that the employer, the hospital, may be held responsible for the employee's negligent acts when injury occurs. And so the hospital just can't skate by, right, without being held accountable. Now, hospitals and other healthcare facilities have evolved into dynamic systems that coordinate the care provided by a range of healthcare professionals. Now, as a consequence of these changes, the courts have expanded the concept of corporate negligence in verdicts rendered against healthcare giants. And so these hospitals are, they're going to have a major problem just the same. Now, one of the most powerful allies the nurse has in any healthcare setting to facilitate positive change and reduce personal and corporate liability is the risk manager. All right. Some of you may not know what the risk manager does, but they're very integral to the hospital's mission, right? To provide or to have systems in place to keep patients safe. Now, the risk manager is a professional who tracks accidents and injuries that occur in the facility. This is also, I wanted to mention to you guys, those of you who don't really want to stay at the bedside forever, but this is another job or role that you might consider a risk manager. I think they also make pretty good money, believe it or not. But your job would be to track accidents and injuries that occur in a facility, right? Now, the job of the risk manager is to establish and also strengthen systems within the agency in order to reduce preventable patient injuries or deaths, and to eliminate the loss of revenues as fines or payment of damages through the insurance carrier. So the risk manager identifies these issues and maybe a systems issue. They're more focused, I believe, on a systems issue more so than individual. But it may be something within the system itself that is unsafe and that is causing patients a lot of problems. And so this is when the risk manager comes in, identifies these issues, and then at some point in time recommend um, steps that can be taken to strengthen that system so that patients do not continue to incur, these issues. Right. Now, the risk manager may assist nurse managers in the development of effective policies and procedures to improve practice. And so they would be a part of that process as well. Maybe the policy has to be changed, the procedures has to be changed in order to reduce risk. Now, the risk manager also is knowledgeable about federal and state administrative rules and regulations affecting healthcare systems, healthcare licensing laws, and healthcare case law. So they do have quite a bit of knowledge about the laws concerning these institutions, and therefore they can be some of your best resources. Now, this knowledge is essential to prevent inadvertent violation of healthcare laws and also to reduce claims of negligence and malpractice within the institution. Got a really great risk manager. They are identifying issues and what have you. Then your hospital can remain solvent. You're not all tied up in a lot of lawsuits. I remember there was a time years ago that Mayo Clinic never settled cases. They always went to court, they went to trial or whatever, but they never settled cases. And I'm not sure if that's changed now, but years ago that was a big deal, way back when. As far as reducing legal liability, we continue. Now, nurses are legally bound to report critical incidents to their nurse managers, agency administration, and also the risk manager through a formal intra-agency document entitled the Unusual Occurrence Report, or in some institutions may be referred to as an incident report. Now, this is a very important piece of this information that I'm providing to you guys at this moment, because you need to know what to do when an incident requires that an incident report or this unusual occurrence report. The unusual occurrence report just sounds better, right? Seems more apropos. And so you need to know the rules concerning this, and we'll go through some of these. So emphasis on patient safety and quality has resulted in renaming the incident report in many healthcare institutions. And so that's one of the reasons why they've come up with the unusual occurrence report. We called it incident report for years. It's funny how research changes so many things, right? Now, the document is frequently referred to as the unusual occurrence report, but also it has been known by other titles, such as a quality variance report. Now, this form often is directed to the risk management department through the nurse's immediate manager. And of course, this incident report is done, of course, on a system, a computer system is, they have a site where you can go to and enter all this information. And let me tell you something. Patients who fall, for example, that's an incident report, by the way. And the amount of work that goes into filling out these incident reports is just it is just enormous, right? And so it makes you take every measure possible to keep that patient in a safe, if you will. For example, in your some of your hospitals, probably most of them, I would say, if not all, we turn on bed alarms because sometimes we forget to turn on bed alarms, and before you know anything, the patient is on the floor and injured. So it makes you carry out certain tasks, such as leaving the bed alarm on, making sure you're assessing the patient to see if they are in their right frame of mind, making sure you explain to the patient about don't get up without assistance, push a call light. In other words, leave your bed in low position, your call light in place, call for assistance if you need it. So in other words, you're basically anticipating that something can happen, and therefore you try to do everything you can to get out in front of it. All right. And it can save you from having to fill out this very long report, the incident report. Now, the nurse manager has an opportunity to review the written report and begin the process of collecting information, investigating and mitigating any identified systems flaws in a timely fashion, depending on the nature of the incident, of course. So the nurse manager gets the report, and perhaps it might be something that he or she can do that can prevent it from occurring again or with increasing frequency. Now, this report is then going to be forwarded to the risk manager. Usually, it is within 24 hours. Unfortunately, a report released by the Office of Inspector General, the OIG, found that hospital incident reporting systems captured only an estimated 14% of the patient harms events experienced by Medicare beneficiaries. So there are things that are happening and it is not being reported, only 14%. Hospital risk managers, clinical managers, and administrators investigated only those reported events that they considered most likely to lead to quality and safety improvements. So they're kind of cherry picking, if you will. Now, a few policies or practice changes were implemented as a result of reported events. So, which is pretty scary when you think about it. I mean, it's like you recognize there's a problem, but then you're not really changing practice or policies in order to prevent these situations from reoccurring. And so they can continue to reoccur, right? So not very good. Now, critical incidents that result in patient injury or death eventually may lead to a malpractice claim. All right. Now, because state laws vary as to whether the incident report may be discovered by the plaintiff's attorney in a lawsuit, the patient, it is essential that the nurse follow appropriate procedures when completing and filing this particular document. And take a look at, well, you're probably looking at the slide, I'm sure, but it talks about incident reports or unusual occurrence reports. So nurses are legally bound to report critical incidents to the manager. That's a given. Critical incidents that result in patient injury or death may lead to a malpractice claim. This is one of the reasons why we have these incident reports, so we can reduce the number of these critical incidents. No appropriate procedure for completing and filing the incident report. And this is really important here, this next bullet, as they all are, but this is really a point I want to drive home. It says, describe events objectively. Avoid subjective comments or personal opinions. You want to be objective, right? For example, let's say you did your rounds, you saw your patient is in bed, you left the room to go get maybe some medications, you come back, the patient is on the floor, right? So you don't document in your incident report that the patient fell and hit the floor pretty hard because they're bleeding from the back of the head, let's just say. Well, the only thing you can actually say if no one actually witnessed the fall is that patient found on the floor with, maybe bleeding that is coming from the back of the patient's head, something like that. In other words, you have to be objective. Document what you see. Don't give your opinion. Don't opine, or all those kinds of things. Just your objective assessment of the situation. All right. Never note in medical record that an incident report was completed or filed. This is another significant point to think about. If an incident report was filed, you do not go to your nurse's notes and enter incident report was filed or was created. You don't do that. All right. You do not mention it. Right. Never photocopy the incident report because this information is discoverable and it can end up in the hands of the plaintiff or the patient's attorney. Not that you're trying to hide anything, and then maybe you are, maybe the hospital is. But anyway, so I don't want to speculate. Don't photocopy the incident report. Physician's order for an incident report should not be written in the chart. So it shouldn't be in the nurse's note. It shouldn't be in a physician's order either. And report every unusual occurrence or incident. Every unusual occurrence or incident. And so that when it says cover every, that covers everything, right? You don't get to cherry pick in these cases. All right. Intentional torts in nursing practice. So ordinarily, in the course of carrying out one's nursing duties, breaches in the applicable standard of care are assumed to be unintentional acts. In other words, the nurse just didn't intentionally go in and cause the patient harm. So as noted, this civil wrong, it would be referred to as an unintentional tort. Now, an intentional tort, rather, is a second category of civil wrong. It involves the direct violation of a person's legal rights. In this case, the nurse intends to perform the offensive act, although normally most nurses do not mean to harm the patient. Now, there are some acts that are considered to be intentional torts, and that would be assault and battery. Assault is basically, you can verbally say threaten someone. It can be considered assault. And battery is the physical, a physical thing that happens. Maybe you touch the patient when they told you not to touch them. And when they are sound mind, you cannot touch a patient, right? Because it can be considered battery. You can go to jail for that. Defamation of character is another intentional tort. False imprisonment. You tie somebody up in restraints when they are of right sound and mind. Invasion of privacy, right? And intentional infliction of emotional distress are all intentional torts. Now, in the case of intentional torts, the patient or plaintiff does not have to prove that the nurse breached a special duty or was negligent. So the bar is a little lower here. The duty is implied in law, the duty to respect a patient's right to privacy. Now, in general, legal remedies for intentional torts include fines, punitive damages, although some intentional torts rise to the level of a criminal act, such as battery, and may result in jail sentence, as I just mentioned. Now, a crime is an offense against society, all right, defined through written criminal statutes or codes or laws, if you will. A criminal act is deemed to be conduct so offensive that the state is responsible for prosecuting the offending individual on behalf of society. Now, legal remedies for crimes include fines, imprisonment, in some cases, the execution of the death penalty. Now, criminal acts are classified as either minor offenses or what we refer to as misdemeanors, or also major offenses, which are referred to as felonies. Now, misdemeanors that nurses commonly are charged with include illegal practice of medicine, practicing without a license, failing to report child or elder abuse. That's all even a part of renewing your license. You have to do like some little courses, if you will, on this because you are it is mandated that you report suspected child abuse, elder abuse, falsification of patient records, medical records, and also assault and battery and physical abuse of patients. Now, felony acts may be committed against the federal government and generally involve drug trafficking offenses and increasingly fraud and billing for services of Medicare patients. That's something you do not ever want to be involved in, especially, well, both of those, but that fraudulent activity with Medicare, they really come after you. Now, other serious criminal acts include theft, rape, and also murder. A nurse found guilty of a felony generally serves time in prison and usually suffers the permanent revocation loss of his or her nursing license. And so they will take your license away when you are involved in a felony. I think I may have told you guys you actually have to self-report. Whenever you get arrested and what have you, you're supposed to self-report. I don't know how many people would do that, but if they ever do an audit and find that you were arrested before, there will be some significant consequences. All right. Now, as far as advanced directives are concerned, society now recognizes the individual right to die with dignity rather than be kept alive indefinitely by artificial life support. As a consequence, the majority of states have enacted right to die laws. Now, these statutes grant adults who are competent the right to refuse extraordinary medical treatment when there is no hope of recovery. In other words, they may be terminal. And so it allows them to refuse any heroic treatment measures. Now, the term advanced directive refers to an individual's desire regarding end of life. All right, it's kind of the umbrella term and whatnot. Now, these wishes generally are made through the execution of a formal document known as a living will. Right? Now, right to die statutes vary from state to state. And so what this means is you must become familiar with your state-specific statute regarding advanced directives. Now, a living will is a legal document, and it is a type of advanced directive in which a competent adult, or when they are competent at that time, makes known their wishes regarding care that will be provided in the final stages of a terminal illness. In other words, if right now in your right frame of mind, maybe you witness many patients who suffered until the end because no one wanted to pull the plug, if you will. You can make that decision right now while you're competent of what you want to occur if you were ever in that situation. All right. Now, a living will generally contains, so for example, designation of the individual or proxy or surrogate, they call them surrogates, who is permitted to make decisions once the patient is incapacitated and no longer able to make decisions. And this is often referred to as decisionally incompetent or decisionally incapacitated. So you're able to name a person, someone who knows you well, called a proxy or surrogate. They know what your wishes are. Maybe you expressed to them many times, I don't ever want to be in that situation. If there's no hope, just let me go. And you may have had that conversation with this quote unquote proxy on a number of occasions, and you may not have shared this with even closer family members. Let's say if it's a girlfriend you're living with, boyfriend or whatever, you may have expressed these things to your companion and not to a family member. And so if you make them your designated surrogate or proxy, they can tell the family, well, so and so told me that this is what they would want if in the event a situation like this occurs. Of course, that doesn't mean that it won't be a knockdown drag out, right? The family members may still refuse and say, you don't know what you're talking about. They would never agree to do something like that. And it becomes a big problem, right? And so, again, you get this legal document, this living will, and this will hopefully prevent an uncomfortable situation. Now, specific stipulations regarding what care is accepted and which procedures or treatments are not to be implemented. This is all outlined in the living will. What you can do, what you can't do, what's acceptable to me. All right. Now, authorization of the patient's physician to withhold or discontinue certain life-sustaining procedures under specific conditions is what this document will allow as well. And this is just a few that I named. Your book has more, so make sure you take a look at the other examples. Now, a living will must be written in some cases using a state-specific document. There's a formal document that has to be used. It has to be dated, signed, and also witnessed. If asked to witness a patient's living will, the nurse should refer the matter to the agency's risk manager. Consult the risk manager. You don't sign as a witness. It may not be lawful in a particular state for the nurse to witness this document. And so here again, it boils down to knowing your state-specific laws or statutes. Now, a more specific type of living will that the patient may execute is known as the medical or physician directive. Now, this document lists the desire of the patient in a particular scenario, such as whether he or she would want to be resuscitated if cardiopulmonary arrest occurs. All right. The physician writes DNR, do not resuscitate orders, on the basis of written medical directives dictated by the patient. See, we should be doing this ourselves and not depending on someone else to do it, because it creates uncomfortable situation. Now, this medical directive, when properly executed, it will provide physicians with some immunity or with immunity from claims of negligence or intentional wrongdoing in the patient's death. And so if this document outlines what the patient wants and the physician carries out the patient's wishes, you can't sue the physician. All right. Now, the physician must also follow any state-specific statute and the agency's policies and procedures before writing a DNR order. I mean, the physician just can't write a DNR order, there are certain policies and procedures that directs him or her and how to carry this out. And so that is what must be done. As far as do not resuscitation orders, research has discovered a serious lack of uniformity among and within healthcare facilities in making certain that direct care nurses and providers are aware of a patient's DNR order or status. So even within the same hospital, you have these different units. They're not on the same sheet of music, if you will. The lack of awareness can result in a significant risk of confusion and error and contribute to claims of negligence. So, for example, if you did not do your due diligence in knowing whether or not this patient is a DNR, you might get sued if you say if the patient was a DNR and you brought the patient back, they can sue you. All right. I would tell you when you guys are getting report, make sure that usually they have a place on the report sheet, DNR status or whatever, and you want to make sure you know that patient's status. Now, a good clue would be that, say, if you're working in an ICU or even on the regular floor, depending on the patient's condition, if the patient is elderly, they got all sorts of comorbidities, they just are just not in the best of shape, right? That should really prompt you to say, what's this patient's DNR status, right? Of course, if someone comes in at 20 years old, 30 years old, you know, um, don't say that, or don't think that they wouldn't have a DNR order. It's possible, uh, maybe remotely possible, but it is possible. So do your due diligence. But I'm just saying, there are certain cases that when you're getting report will prompt you to ask the question, is this patient a DNR? And then you kind of go through what can and cannot be done. All right. Now let me say this all to you also. If you let's say if you're in the patient's room after the patient comes back from surgery, you're in the patient's room carrying out your nursing tasks, the family members are in there, and the patient begins to cold, and the family members say, just go ahead and let them die. I mean, they're just too sick to bring them back and this and that and so forth. If there is no order, you are going to have to code that patient. Until you get an order, you need to carry out your heroic measures, duties. All right, keep that in mind. No order, even if it's a family member there, the husband or wife or whatnot in the room, uh, uh, informing you to stand to step back. Don't do anything. Let him die or let her die. You need to start CPR and carrying out your cold interventions. Now, the nurse has an absolute duty to respect the patient's wishes in the case of a DNR order. A lawfully executed DNR order must be followed. All right. Nurses have been sued for failure to observe DNR orders. You brought someone back who didn't want to be brought back. They had a terminal illness. Now they have to come back and face life all over again. And so you can be sued. Now, claims against the nurse include battery, right? Because you're touching this patient, you're pushing on the patient's chest, you're sticking the patient, you're doing all these things. There's also negligent infliction of pain and suffering and wrongful life, not wrongful death, but wrongful life. You brought them back. All right. I thought that was a cute play on words, but it is even so. Anyway, the three problems may arise regarding a DNR order. One, a physician refuses to comply with the patient's wishes and initiates resuscitation. The other one is the patient revokes consent to the DNR order. All right. In other words, the patient changes their mind and say, "Hey, um, uh, You can, code me, perform your heroic measures or whatever it is they say. They got a DNR order in place, but they're saying save me anyway. You have to. All right. And the other one is a family member demands that the DNR order be rescinded despite the patient's continued objection to resuscitation. And this is why a patient, when they're in their right frame of mind, alert oriented, times three, coherent, and so forth, if that patient puts forth this advance directive, no family members can come back and change that. Guess that's kind of the example I was given about somebody comes back from surgery and was beginning to code, and the family member says, uh, don't do anything, let them die or something. Want that insurance, right? Just messing with you. Anyway, so if one of these issues arise, the nurse must act promptly to enlist the assistance of the nursing supervisor or a hospital administrator. One must remember that a patient may revoke a living will, including a DNR, at any time. The ANA has published a position statement, nursing care and do not resuscitation, and allow natural death and decisions in order to clarify the nurse's roles and responsibilities related to DNR. So you may want to take a look at that, educate yourselves more on the topic. Now, in 1993, the Uniform Health Care Decisions Act was approved. The Act recognizes an individual's right to make decisions about health care and enables a patient to accept or refuse treatment. Now, the Act is also designed to give the patient autonomy to make end-of-life decisions. Durable power of attorney is a legal document that authorizes the patient to name the person considered the healthcare proxy who will make day-to-day and final end-of-life decisions once he or she or the patient is decisionally incompetent. Now, naming a proxy who is intimately knowledgeable about the person's true wishes is important to ensure that the patient's desires will be carried out when he or she is no longer able to make decisions. That's what I was telling you guys about. Say if you're living with your boyfriend or your girlfriend, and you got that situation, and this situation arises where you require heroic measures, then that person who knows you intimately, they can step in and say, no, we're not going to do this because this is what their wishes are. Now, healthcare law experts recommend that individuals interested in naming a proxy seek legal assistance with executing a durable power of attorney for healthcare. This is not something you want to just sit on. You want to be proactive, especially if you know that you're in a relatively poor state of health. You want to just go ahead and get this in place as soon as possible. Now, nurses may be asked questions about living wills and durable power of attorney for health care by the patients and their families. And so you might be asked these questions. All right. Now, an important aspect of speaking to the patient about these issues is to provide the written materials. There should be written materials about advance directives that are required under the federal statute, the Patient Self-Determination Act, which was passed back in 1990. So you will give them the information, and of course, they can make a well-informed decision. As far as informed consent is concerned, for any patient to make meaningful choices about a particular procedure or treatment, the provider must convey certain material information. Now, under the doctrine of informed consent, the physician or advanced practice nurse has a duty to disclose information so that the patient can make intelligent decisions. Now, this duty is mandated by federal statute, for example, Medicare, Medicaid patients, and state law, and is grounded as well in common law. So it has to be done. In the case of routine as well as specialized care, the primary provider must disclose the following: the nature of the therapy or procedure. This is what when you're giving when the physician is providing informed consent. They have to talk about the nature of the therapy or procedure, expected benefits and outcomes of the therapy or procedure, potential risk, of the therapy or procedure. You may not be able to walk again, right? Alternative therapies to the intended procedure and their risk and benefits. What else can be done? What other alternative? And also risk of not having the procedure if you decide to against it altogether. This is all a part of informed consent, and we do not give informed consent. That is up to the physician to give. I believe we witnessed them signing the form, but we don't actually give it. Now, this duty to disclose, yeah. So this duty to disclose rests with the provider, and the provider, physician, nurse extender, they cannot delegate this to the registered nurse. Provider, again, must do this. When the nurse has reason to believe that the patient has not been given informed consent for a procedure, you should notify the provider immediately. In no case should the nurse proceed with initiating any part of the therapy that he or she is responsible for implementing without this patient being duly informed. Now, the patient's questions or concerns should be documented in the medical record to indicate why there has been a delay in carrying out the procedure. If the nurse is responsible for witnessing the patient's signature on a consent form for the specified procedure, this process also should be deferred until the provider has had an opportunity to clarify the patient's questions. And so just wait till the physician comes, provide the information, and then you can witness afterwards the patient's signature, not before. Right. The next bullet point here, main bullet point, is the right to refuse treatment, the right to refuse diagnostic testing, treatment, and also care. Now, as noted, an adult of sound mind has a right to refuse any treatment that has previously been agreed to. If a patient who is under the nurse's care refuses treatment, the nurse has a duty to notify the primary provider, right? The same principles pertaining to the informed consent process apply to situations in which the patient refuses care, benefits, risk, and so forth. The physician or advanced nurse practitioner should provide the patient with information about the consequences, risk, and benefits of refusing therapy. Now, the provider also must explore any alternative treatments that may be available to the patient. It may cause the patient to, change their mind if there's an alternative. So something that has to be kept at the forefront of your mind. As far as leaving against medical advice, this is something that you are going to deal with in your practice. Now, a common allegation made when a patient self-discharges against medical advice and is subsequently injured is that the patient was not fully apprised of the risk inherent in leaving the facility. In other words, we didn't explain it enough to the patient to understand that if you leave with that blood glucose level of 600, you're going to die, or you might very well die. All right. Now, if a patient intends to leave the facility without a written order, the nurse must act promptly, and I mean promptly, to notify the provider to intervene. Now, when circumstances suggest that the person may suffer immediate physical harm, The nurse must clearly articulate the dangers of inherent in leaving. You're gonna die, right? Now, this precautionary statement is reserved for situations in which life or limb of the patient are at risk, and the appropriate providers, physicians, or advanced practice nurses are not available to address the direct and indirect consequences with the patient. Maybe they're not available, and now it's you, and you have to, with your nursing, your knowledge of disease processes and so forth, you will have to make this patient to understand, hey, you may lose, your limb, or you may die, that would be something you will have to do in this case. Now, the nurse should document all of these actions and any communication with the aforementioned parties. And so you better make sure your documentation is tight when you have these types of situations, because you know how people are. They don't take responsibility for their actions, and they're liable to come back after you and say, you should not have allowed me to leave. You know what was going to happen to me, right? Now, if the primary provider has not arrived before the patient leaves, the nurse's note should reflect the specific advice given the patient, which should include the fact that leaving the facility could aggravate the current condition and complicate future care, result in permanent physical or mental impairment or disability, and also result in complications leading to death. All of the things you must inform this patient about. All right. Now, in a study of patient characteristics, who are the type of patients that leave AMA or against medical advice, right? Um, it found that these patients are of low socioeconomic status, substance abuse. They came in, for some drugs, and you didn't give it to them, and so now they're leaving. Sickness within the family. I have to go take care of my mom. Underlying and often untreated psychiatric disorders, anger and anxiety about the admission diagnosis, and lack of effective communication with team members correlate with self-discharge. These are the type of patients. So why this is important is now that you know this, once you listen to this recording, you know what patients to anticipate they might leave. And so kind of get your ducks in a row, so to speak. Anticipate that they might be one of those who will leave. Now, nurses and providers should collaborate to address immediate patient concerns, right? You want to try to allay their concerns as soon as possible. Also, communicate a time-limited plan of care, and advocate for appropriate consultations. For example, psychiatry, social work, pastoral services, and pain management, in order to reduce the likelihood of patient self-discharge. If you implement these measures sooner, it might avert the patient leaving and going, leaving the facility and be in danger, of course. Now, almost all healthcare facilities have an AMA form that the patients are asked to sign when they decide to refuse or discontinue the order therapy or intend to leave the facility. Now, the value of the document in countering a claim of negligence, should the patient or family later sue, would depend in great part on the quality of the nurse's charting. And so you are going to have to make sure your charting is tight surrounding leaving against medical advice. You can't just say, well, if you want to leave, just go ahead and leave. That's one less patient I have. And then your documentation is subpar, to say the least. It really gets you jammed up. The last topic we will look at is the use of physical restraints. This is an extremely important topic here that you guys want to hone in on, because you can go to jail for restraining people when they're competent. So So even though it's the last topic, but equally important area of patient rights to discuss is the right of competent adult to be free of restraints. If you're a competent adult, you should be able to move about freely without being restrained. And sometimes we have restrained competent adults because we thought that we were doing them a favor, right? And that can result in battery and a host of other things. Now, even patients with mental illness cannot be incarcerated. This is what they're considered to be incarcerated when you restrain them without due process. And the institution must have the treatment and rehabilitation services necessary to reintegrate the individual into society. Right now, restraint of any kind is a form of imprisonment. And the reasonable and prudent nurse will closely adhere to all laws and rules and policies pertaining to the use of restraints. The goal when restraints are clinically indicated is to use the least restrictive restraint and only when all other strategies to ensure patient safety has been exhausted. Sometimes a patient they're so confused they may require Haldol, which is chemical restraints, but less restrictive than tying them down, like maybe 4-point restraints. Now, patients may never be restrained physically or chemically because there is not enough staff to properly monitor them. In other words, sometimes, say you're working short and short staff, and you got this patient who they just seem like they may get out of bed and wander off, or get out of bed and fall and injure themselves. And so we say, well, let me go ahead and physically or chemically restrain this person. You can't do that. You can't do that. You're in a tough situation, I get, but unfortunately, you cannot do that. Nurses do have a legal and ethical duty to report institutions or individuals who violate patient rights through unlawful restraint. Now, as noted, one of the most common allegations leveled against nurses is failure to ensure patient safety. Nurses in many practice settings must balance the right of patients to unrestricted control of their bodies and movement against the need to keep vulnerable patients safe from harm. Now, the use of seclusion, uh, chemical restraints, for example, Haldol, physical restraints, including a vest, mittens, belts, and wrist restraints, is governed by federal and state statutes and accrediting bodies such as the TJC or the Joint Commission. There was a time years ago that if you just place mittens on someone's hands so that they don't grab tubes and lines and so forth, if that wasn't considered restraints, as long as you didn't tie the restraints to the bed. But now just restricting their hands with mittens are considered restraints. And so you have to document those and get orders for them and assess these patients while they have these types of restraints. But they are considered restraints, in other words, is what I'm trying to get you to see. And so I found out about this over at UF Health when I was doing clinical with some students. This happened, of course, at Mayo when we didn't have to document that the patient was restrained because they had mittens, but possibly even over there, you have to still document it. It would be appropriate to document it. Now, many nurses do not realize that even bed. Now, this is something to really think about. Even bed rails. When you pull up bed rails on all 4 sides, is considered restraints. That's why when you go to a hospital, sometimes you see where they're like three side rails are up and 1 is down. All right, like the lower left or right is down. It's because bed rails can also be considered restraints. Chair trays also fall under the category of physical restraints. These articles may not be used indiscriminately. So, like you take the chair trays and you basically have it situated in front of the patient where they can't get up and move about freely, it can be considered restraints, and so you have to be very careful. Now, violation of restraint statutes and the administrative rules and regulations promulgated to enact these laws can result in stiff penalties. If you violate these laws concerning restraints, can result in stiff penalties. The institution can actually lose its Medicare contract, or what they call decertification, and the Joint Commission, the Joint Commission accreditation. And this would essentially put this hospital out of business. Again, I told you, if you're not getting federal dollars, it's hard for you to make it because a lot of people don't have health insurance. So, you know, now patients and families may initiate civil suits for unlawful restraints, resulting in monetary damages if the plaintiff succeeds in the suit. Right? So you can be sued. Charges of assault, battery, and or false imprisonment may be leveled against nurses who use restraints improperly. So you need to really read that policy on restraints when you guys are out there. You know, that's something say if I was if I was to go into clinical with someone, I would probably assign a few students to a computer system to just study the hospital's policies. I may select certain policies that they have to look through, and of course, in post-conference, we'll talk about what some of these policies are. That would be a great project to incorporate in clinical. And unfortunately, in most cases, as new nurses in orientation and so forth, we don't really get a lot of time to, let's say, give a person a week to just sit down and just go through these policies and procedures. You don't get that. So you have to more or less learn this stuff on the fly, unfortunately. Now, careful nursing documentation is also essential when restraints are applied. The patient's mental and physical status must be assessed at regular and frequent intervals as prescribed by law and agency policies. Because say if the patient was having an episode where they were confused, all right, and well, maybe that was 5 hours ago. Now they're with it now, they're mentally, cognitively intact, but yet you still have them in restraints. So you have to continue to assess these patients frequently so that you can remove these restraints as soon as possible. The chart must reflect these assessments and the frequency with which restraints are removed. Typically, in the acute care setting, we loosen the restraints every 2 hours. We check for circulation because sometimes they can be too tight around the wrists or ankles. So we check for circulation. We check the scan. We do passive range of motion exercises with the patient if they can't do anything on their own. And before reapplying the restraints. So this has to be done again every 2 hours and possibly more frequently, especially let's say if the patient has to use the bathroom frequently. Maybe they want a bedpan, maybe they want a urinal. You have to be able to assess these things. You have to be able to give the patient something to drink, something to eat, because you're restricting their movement. They can't do these things on their own. And therefore, you want to make sure you're providing these services for them. So those neurological skin assessments of the limbs and other body parts covered by restraints will have to be entered into the record. If it comes back that the patient incurred an injury, you can have some problems. Now, written orders for restraints must be timed and dated, right? Because they're typically renewed, I believe, is every 24 hours. And renewal of orders must be accompanied by evidence of medical evaluations and nursing reassessments. And so, in other words, you have to be able to justify why this patient is in restraints. So your assessments are going to be very important. Now, on the basis of the aforementioned information, some nurses are under the misconception that current law prohibits restraining patients until a written order is obtained. This is not true. If this patient is actively being belligerent, anxious, trying to get out of bed and so forth, you can restrain the patient at that moment. This is an emergency situation, and then you can get the order afterwards, right? So nurses may lawfully apply these restraints in such an emergency situation. And because what you're doing is you're using your independent nursing judgment, because then you determine that no other strategies are effective. And so I got to restrain this patient right now to protect them from themselves and protect staff. Now, the physician must be contacted promptly to discuss the patient's condition and the need to restrain and to obtain an order for temporary continuance of restraints. Right? Remember, this has to be renewed every 24 hours. The nurse is guided in the decision to restrain by knowledge of the laws, the agency's policies and procedures, qualifications of the staff, and conditions on the unit or in the department as well. So this will be all left up to you to decide in these circumstances. Well, folks, that is about it. That was quite a bit of information. This one actually lasted almost 2 hours. Most of them have not been lasting that long, but I did, well, again, there was quite a bit of information here that I think you will find very helpful and hopefully keep you safe, keep our patients safe. You want to hold on to your license and your monies, your reputation, and so forth and so on. I appreciate you all. Thank you.